So the case Cooley v. Foreman has taken the world by storm. I think everyone and their mother is just referring to it as the Afroman trial. And if you are one of the 9 people in America that is not tracking this case today, Chance, will you give us kind of just the background and what happened here?
So for those of you who are not of a certain age and don't remember, Afroman was a rapper. He is a rapper. He still tours. Most famous in the early 2000s for a song called Because I Got High. Talking about the struggles with marijuana use, and
the struggles.
Yes, and he's sort of a joke rapper. That's what his whole shtick was. And a few years ago, his house was raided by the local sheriff's department, and he had surveillance cameras in his house. So he had video footage of them breaking into his house, kicking in his door, breaking down his gate. And searching his suits and his CDs and everything else for narcotics and kidnapping victims, of which they found none. and so he made absolute bangers of singles like, Will You Help Me Repair My Gate? And Will You Help me repair my door?
All to the classic tune of But Then I Got High.
Yeah.
With the same artistic value.
And so the police officers who were involved in these videos and involved in these songs and these singles that he released sued him for defamation. And after an extended trial, Afroman won. And so what do we want to talk about?
And America won.
Well, let's start with some of the details of this, because the details are funny and kind of sad. But one of the elements of the Will You Help Me Repair My Door is this pound cake. This lemon pound cake, that there's footage of a police officer, I don't want to insult this poor man any more than he's been insulted, but a somewhat portly deputy walks past this lemon pound cake and does a double take. And so this lemon pound cake has become kind of emblematic of the suit itself, and some harassing behavior. I'm not going to say harassment because that carries legal connotations, but some harassing behavior was aimed at the sheriff's deputy. Many lemon pound cakes.
They sent him like 100 lemon pound. People started sending lemon pound cakes to the sheriff's department.
There's a separate song for that one.
There's
a lemon pound.
He
cake
has a separate
song
single. Yeah,
that went viral
to the same tune, more or less.
Well, they're all different tunes.
Slightly.
To those true connoisseurs of music, they're all different.
Yes. So there's that aspect of it. There's kind of this silly, teasing, I would say lighthearted side of this. And then also during the pendency of this trial and wrapped into all of these issues is some posting that he's doing on social media, that Afroman is doing on social media, calling these people out by their names, making allegations about them. Maybe not allegations is a little strong. He's just asking questions, if you will. This officer's brother is a pedophile. Is he a pedophile too? I don't know. That kind of behavior that is ongoing in the background at the same time. So that's also part of the suit, but it seems like the real focus of this lawsuit is more of this teasing kind of the songs that he put out and things that he says in the songs, like he addresses one of the officers and says, I'm having sex with your wife, that kind of teasing language. There is one sort of teasing thing that he says that actually has some pretty important implications, which is he accuses the officers of taking $400 from him, which ended up becoming a pretty important fact at trial. Do you want to talk about that a little bit, Chance?
Yeah, well, it's interesting because they are on video taking money out of one of his suits, and there was a situation where the amount of money on the evidence bag ends up being more than the amount of money that he gets back. So there is a discrepancy. The money goes into the police department, and then on the evidence bag it says this much money was taken, and then the money he gets back is like $400 less than that. And so they accuse him of defamation for claiming that money was stolen. But his argument is, well, what happened to it then?
It's not defamation if it's true.
It's not defamation if it's true. And really, a lot of this stuff, what makes it such a fascinating case, aside from the fact that the guy shows up in court in a full American flag suit, is a really interesting question about what you can say to criticize government officials that may have wronged you. I mean, do you have under the First Amendment the right to insult police officers or to insult government officials? And what the court concludes, and ultimately what this case shows is, to a certain degree, yes, you do, in fact.
Not the court this time. This is the jury.
Yeah,
what the jury concludes.
The jury concludes. And what the American people almost uniformly have concluded over the following weeks is, yes, you can insult government officials. In fact, there's a great tradition in America of insulting government officials that runs back all the way back to, John Adams and Thomas Jefferson, who said some really nasty things about one another during the campaign. So,
and they were even, I guess, they could be construed as false representations of fact even then.
Yeah.
But if they're not to be understood as being true and they're just insults, then that's not a representation of fact.
So I guess there's two questions, and I'm going to start with the broad one and move to the narrow one. The first kind of broad question, Clayton, was this a frivolous lawsuit? Like, would you say this was just brought for the purposes of quelling Afroman's free speech?
Well, I mean, in a certain sense, it does. I mean, if you watch like the first video, what's it called?
Will you help
me repair my door? Yeah.
You might not think that, because that's just, or you would think that it was a frivolous challenge, because it was just a video of them going through, like, these are true factual, like, representations. It's a video of their actual conduct, and he's just kind of like making jokes as commentary to that. So to the extent that that's what the case is about, I would say, yeah, there's some frivolity there. But when factual allegations are actually made, that might not have been true.
Like, for example, stealing money from me.
Yeah.
Because we're in a different kind of class of
right.
error there.
Right.
Yeah.
So I think it depends. It depends on the standard of frivolity. Like, there's these things called anti-SLAPP statutes, which we don't have to get in, but they have different. They're drafted differently depending on the state, and so the level of like frivolity that's necessary to for these motions to succeed is probably different.
Yeah,
it's certainly vibed like.
It seems like it.
It vibed like they did this to punish him for
hurting their feelings,
critiquing a government action.
Yeah.
Because they didn't find anything whenever they searched the house. There were no kidnapping victims inside his CDs, as the lyrics of the song.
It's not that there were no narcotics, but there weren't enough narcotics to be evidence of trafficking.
Right.
Or, well, I don't know. It depends. I guess you would know that, but but there wasn't enough to actually.
They didn't charge him, regardless of whether or not there was enough. They didn't charge him with trafficking. They didn't charge him with anything. And I think that kind of leads to an interesting kind of question. Like, if this case had unfolded exactly the same way, except they had found a woman chained in his basement, would this have gone the same way? Do you think that the jury would have still ruled entirely in favor of Afroman?
So, unlike you, I haven't argued a bunch of jury trials. So you might be able to speak to the way that things would vibe in front of the jury. But it may have. I mean, I think, so much of, and we've talked about this before, so much of constitutional law, though, really is, villains versus villains. It's not always the best person who is the beneficiary of constitutional rights.
You're not calling American hero Afroman.
No, I'm not.
He's not. To be clear, there was no woman in his basement. This is a hypothetical for purposes of education.
Or in his suit pockets.
Or in his suit pockets. Or in his CD case.
And so, whether or not he had a First Amendment right to criticize and make videos criticizing the people that searched his home would be a separate question.
Right.
Than whether or not he had ultimately been convicted. I think the biggest difference is he wouldn't have been making music videos if there had been a woman in his basement. He would be in jail, right?
Hopefully,
and so,
hopefully.
Yeah.
And that's an important thing to separate here. The question before the court wasn't whether or not the search was lawful.
Right.
The question before the court was whether or not he had defamed them by showing videos of them, at one point disconnecting his video cameras, making fun of them, if that was defamation. Yeah, breaking his door. If that's defamation, or whether or not he has a First Amendment right to be able to say those things. It's where the defamation runs into First Amendment law. And so that's what made the case interesting. I mean, had he actually had kidnapping victims, he'd be in prison.
Right. It'd be a very, very different trial that we'd be talking about.
The songs would be less funny.
It would not ring.
The jury would feel a lot less comfortable. The
officer would have been far less interested in the lemon pound cake if there had been.
Don't pay attention to this person, captured. Just, say whether the video is funny or not.
So, Eric, let me loop you in on this one. Do you think that if Afroman had lost this suit, would we have a First Amendment issue? Do you think that this jury verdict would have survived if he had lost? Would this jury verdict have survived the scrutiny of the Supreme Court?
Yeah, I think the First Amendment is implicated because ultimately the question is, how far can you go when you criticize, make fun of, parody government officials? And a lot of what the First Amendment test comes down is things being in the public interest and things being, we're trying to ensure that we are not shutting down legitimate criticism of the government, even if it's made in a funny way or in a parody way. We don't want to give the government the power to shut down criticism against it. And so there are some lines on the very outer ends of the First Amendment. If he had been calling for violence against these officers, then that could potentially, depending on the words he used, not be protected by the First Amendment. But simply criticizing or making fun of government officials is sort of in the core of what the First Amendment is all about. Now, not to get too deep in the weeds, but it would be interesting to see if he could have actually attacked that on appeal. As Chance was saying at the outset, a lot of what constitutional law is arguing about procedural matters and whether you get to make certain arguments, whether you get to stay in court. And I don't believe that he brought a motion to dismiss or any type of a defense on the First Amendment. And so it would be interesting to see on appeal, if he had been convicted, whether any claims or any defenses under the First Amendment may have been forfeited. But the good people of the jury pool found him not guilty or not
Adams
liable,
County,
I guess,
not
in this
liable.
situation. Exactly. And so, unfortunately, those fun issues of constitutional law will have to wait for the next time that Afroman makes a music video.
So we've got just a few minutes left, and I want to take some time to just examine the contours a little bit of this First Amendment right to attack an officer in their individual capacity, right? We all know that it is protected to say, this thing that this Adams County deputy did in his official capacity was reprehensible and it was terrible and he should not have done it. But when the camera pans to the person themselves, at what point do we say, yes, that individual you chose to be a government official, you chose to be an Adams County sheriff, so therefore, I'm sorry, you're going to get told sometimes that you have a small penis, or you're going to get told sometimes that you smell funny, or whatever. At what point do we say, no, actually you've crossed a line and you can't attack this person in their individual capacity anymore because that has become true dyed-in-the-wool defamation? Or is our position as an organization, or I suppose as the four of us at this table, that at any point in time, an officer can be criticized in any way, personal or impersonal, true or false, because they are agents of the government?
I mean, we're not defamation experts. I think that's
true.
important.
That is important to point out. We don't do this for a living.
And because it's a tort, it's different in every state.
Yes.
Too. So
the
we're certainly
standard-
not Ohio defamation experts.
Well, the question I'm asking is a constitutional question.
So generally, I think that where the breakdown is, are you making a false statement of material fact? Are you saying, hey, I saw this guy murder 3 people, and you know that's false? Well, then, maybe the First Amendment doesn't reach that or protect that. But if you're saying, I think this guy's a coward, I think this guy's any number of things, and that look, like most things in law, it's going to turn so much on context and so much on the facts, and so much of what a reasonable person is going to believe under that set of facts. Mm-hmm. And so there's that meme. Y'all know that meme where it's like there's the building that's tipping over and it's being held up by a stick, and it says the entirety of the American judicial system, and the stick says the reasonable man standard. Yeah. Like all of jurisprudence is held up by this. Like, what would a reasonable observer think you're doing? Are you doing parody? Are you making a joke? Are you giving an insult? Or would a reasonable person think you're making an actual allegation that this person's committed some sort of separate crime? And I think that's where the difference is going to be.
Are we looking at a reasonable person of today, or are we looking at a reasonable person of 1790? Are we looking at the reasonable person, what we would find as not protected today, or are we looking at what the founders would have found as not protected once upon a time?
I'm not sure that it changes one way or the other. I think what you're really looking at is what a reasonable person would think this person is saying. are they making a statement of fact that this other person has engaged in some sort of crime or done some sort of nefarious deed? And that's going to be the same regardless.
Yeah, I think like since 1790, the context has always been a relevant part of that analysis.
Yeah.
And so the context is always going to be present. Like, what does a reasonable person who heard it think?
So we're not necessarily going to use Jefferson calling Adams a hermaphrodite as a barometer for the constitutionality of a given speech.
Well, what's interesting about that particular statement is I think it was someone that Jefferson allegedly paid to be his hatchet man, and this person said that Adams was hermaphroditic.
Oh, okay. Not quite.
Had neither the qualities of a man or a woman is what he argued, and so this was an attack on Adams' character, right? And I think to put that into perspective,
more of an opinion.
It was an opinion about Adams' character, calling him a hermaphrodite, rather than his actual anatomy in some sense. But again, these are the sorts of things that you would have to argue about.
But there is a higher standard, and maybe this is what you were getting at earlier. If you're a public official. It's not just that it has to be false, but the official who's suing for defamation has to also prove that the speaker had actual malice, which means that they knew what they were saying is false. So you can actually say something false about a public official, but if you didn't know and it was kind of just like your mistake, that actually is still protected by the First Amendment.
I think we will probably, I assume, at some point get into the whole New York Times standard of actual malice and all of that. But to avoid getting into that today, just one more general question. How do we feel about the public response to this? Good, bad, indifferent?
I think it's kind of awesome that, and despite how polarized that we are at this point, I think everyone in America was all excited.
Who had that on their bingo card for 2026?
Everyone seems to love this, early 2000s rapper now that he stuck it to the government, right?
Yeah, I think it's very healthy.
I think it's very American. This is it. We don't really care what you're saying, and I'm sure that everyone would find at least some degree of what he said a little bit reprehensible. But at the same time, we are also excited that his right to say it has been vindicated. I think that's
at his trial,
what separates us. Sorry?
And at his trial, he's literally clothed himself with the American flag. It doesn't
literally wearing American flags.
American
yes,
flag sunglasses.
I want to know what judge let him get on the stand in sunglasses. I don't think I've appeared in front of a single judge that would have let a witness get on the stand in sunglasses, but he did, and they were fabulous. Absolutely fabulous. So there's hope for the First Amendment yet. There's hope for our country yet.